Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm attorney John Redmann. Shauna Sanford will be joining us again next week. The last episode we talked about wills, trusts, and estate planning with Carole Neff. Attorney Carole Neff joins us again today as we explore successions, probate, and what happens when you're gone. So stay with us, because when we return, Attorney Carole Neff joins the show to share what you need to know about successions, probate, and what happens when you're gone. Hello, everyone. Welcome back to the show. We welcome back Attorney Carole Neff today. She is an authority in estate planning and succession. She has, in fact, co-authored a 3-volume reference series for lawyers. She is board certified by the Louisiana State Bar Association in those areas. So thank you, Carole, for joining us today.
You're welcome. Happy
just
to
like
be
with
here.
the estate planning episode and writing wills, a lot to cover. So let's start. Define for us, what is successions?
Well, successions, a succession, which I guess would be a noun, would be the term we use to describe what the assets of a deceased person are, what the liabilities are, and that's basically what the succession is, what the deceased person owned and owed.
And so today we're going to talk about what happens after the passing, after someone's gone, what happens. And in connection, this 3-volume series you wrote, maybe we could put that up on the screen. Why don't you tell us, what's this all about?
Well, that's been out for about 20 years, and I've co-authored it with my partner, Max Nathan Jr., and it really is not a treatise that your audience would want to own. It's really written for the practicing attorney and the CPA, and it's really how do you plan an estate, what are the documents, how do you draft them, how do you administer a succession, what are the pleadings, how do you draft them. It's really a tool for practicing lawyers.
And that was obviously a gigantic undertaking. How long did it take you to prepare?
Well, the first manuscript took a year and a half, and then we update it every single year. It's in its 2nd edition, and we have a love-hate relationship with it. It's a labor of love, but we have to keep it up to date, and so it's in a loose leaf format. So we're right on top of all the changes in the law constantly.
Yeah. And it's a very highly regarded treatise. I know that other attorneys who practice in your field actually spend good money to have that book at their elbow, at their
we hope
close
so,
by.
yes.
So, and you have to update it every year because laws change regarding successions.
Laws change constantly. Federal law changes. Louisiana law changes. So we write about those changes, and sometimes that changes how the documents are prepared. Sure. And so we're constantly revising it.
All right, well, let's get right to the topic then. So when you're talking about successions, you often hear the word probate court. How does that relate to this topic?
Well, the probate court and the probate process is where the court does assist in the process of transferring those assets to the parties who are supposed to receive it. So probate applies when somebody has a will, and that would be the court assisting in dispersing the assets to those who are named in the will, if the will is valid. It also is the process when someone dies without a will for the court to participate in identifying who the proper heirs are, who's entitled to receive, and that process to distribute the assets to those individuals.
And for those who didn't tune into the last show where we defined wills, a will is where and it's a very special document, you have very special steps to have a valid will. That's where you define, when you're the will writer, what you want to have happen to your estate, what you own, all your assets when you die.
That's correct.
And if you don't have a will, the law determines what happens. And
correct.
Basically, it goes to family and certain whoever's closest, your children first.
And it also defines what powers and rights people have with your assets.
Okay. And so probate court is, or probate is the process whereby all the things on the checklist are checked. Do we have a valid will? Are all the heirs properly receiving their portion? Sometimes if you're a forced heir, in Louisiana there's forced heirship, certain children of a certain age, or unless they have physical or mental limitations, they're required to get part of your estate too. Probate court checks into all that?
Yeah, and actually that is what the probate process is all about, to identify the assets, to determine what liabilities there are, so that at the end of the day, when the estate is closed, the distribution is to those who are really entitled to receive.
Okay. Now, who do you go to when someone has passed away and let's say they have a will or they're not sure if there is a will, who do they go to for help in getting the succession open and getting the probate started?
Well, they would go to a lawyer that does succession work, and hopefully someone who specializes in the successions.
Right. And you could go to Joe Blow or Susie Blow, who practices everything, including, tax, immigration, whatnot, but you run the risk because the area is so specialized. The safest course is to go to a lawyer who practices exclusively or almost exclusively in successions and estate planning.
And yes, indeed, and that doesn't always cost more. Sometimes you have so many efficiencies from the person who specializes in it that it costs less than when you're paying someone who really doesn't work with it all the time.
Sure, because you know how to do it like you know the back of your hand, and therefore you don't waste time learning the process, and you don't waste time doing the wrong steps.
Exactly, and we have paralegals that work with us who do a lot of the legwork, and they're billed at a lower hourly rate. It can definitely save on cost.
So when you have someone who's passed away in your family and you need to go see a lawyer to help out with this, how does that lawyer get paid? Do they get paid out of the estate of the person who died? Do they require payment up front? How does that work?
That varies from lawyer to lawyer, but the obligation to pay is the estate's obligation. Okay. So it is the estate that pays for it out of the estate assets. But if the estate is insolvent, there's more debt than there is assets. Sometimes there's an issue, and some lawyers are going to require some upfront funds. Yeah, it depends on who handles it.
And the estate is just one of those terms of art that means everything that the person died in possession of.
Correct.
Assets and debts, correct?
Correct.
Okay. And if the lawyer can be paid out of that, then maybe the surviving spouse, children, they understand that they may not have to front the cost.
Correct.
It may, depending on the lawyer they work with.
Correct. And even in terms of fronting the cost, if they're allowed to get access to the funds of the deceased person, then they can use those funds to pay for the cost. Okay. And normally that's how it is done.
Right. And if there is liquid assets or cash in a bank account or a CD that could be cashed out, the court can give approval without many delays, assuming there's no hitch.
Correct. And even in some estates, and the majority of states now in Louisiana can appoint a succession representative to be independent of the court, and we've been able to do that for the last 10 or 11 years. That allows someone to be able to access those assets without having to keep running back and forth to court to get court approval to do that.
Yeah. The use of trust in successions. We talked about briefly in the last show how trust can play a role in planning, in writing your will and preparing for your passing. What happens if there's a trust in place during a succession?
A lot of people are creating living trusts to avoid probate. And there are certain states where it's very, very popular, and it was something that actually didn't even work in Louisiana until the last several years. It works in Louisiana, these probate avoidance trusts, but in Louisiana we have such a simplified independent succession administration now that there's really no reason to have to do, for most people, to do a living trust to avoid probate, but many people have those living trusts, and what they do there is they actually title all their assets while they're living to this trust, and they have to live their financial life out of this trust, and it's the trust that transmits the assets, distributes the assets, not the court.
And just so we're clear, you use the term a living trust, which is not such an obvious thing to use these days in Louisiana for the reasons you just gave. Let's not confuse that with a living will.
Yes, and people do use those terms and think it's the same thing, but it's nothing the same. The living will is the document where people are specifying that if they're in a permanent vegetative state, that they don't want to be on life support.
It gives your directives, your orders. If you become incapacitated and you're beyond saving, you're just, like you said, in a vegetative state, a coma, that gives authority, in fact, directs people to pull the plug.
Pull the plug, or don't plug in at all.
Pull the plug.
Or don't put the plug in at all.
Right.
Yes.
Okay. Now, in a succession, you have debts and burial expenses, or maybe there's cremation expenses if there's no burial. What about those costs? Do those come out of the estate too?
Those come out of the estate, and the burial costs are considered the most important. So there are priorities. If the estate doesn't have enough money to go around, the first thing really that gets paid is the burial expense.
So if you die and you've got a big debt on your credit card or several credit cards or whatever on a card that you bought that's still money is owed on it, burial expenses come ahead of all those.
That is correct.
Okay.
First in line.
And
the lawyer's fees too, for handling the estate. Because without the lawyer, you
then
couldn't.
who's going to agree to handle it if you don't know that you're going to get paid?
Exactly.
How do insurance and taxes? If you could give me a minute and a half answer on that.
Well, we talked about wills and people writing their wills, but if they have life insurance, it's really not the wills that control where that life insurance goes. The life insurance is going to go to a designated beneficiary with the contract that you have with the insurance company. And if somebody...
So the proceeds from a life insurance policy, if you have a life insurance policy on you and you pass away, but you direct that your wife or your cousin or your best friend gets the benefits, they're the beneficiary, that's not part of the estate.
It's not part of the estate. It doesn't go through the probate process. The will doesn't control it. The judge doesn't have any power over it. And the nice thing for in some estates, especially the insolvent estate, the beneficiary is going to have those proceeds, and those proceeds won't be responsible for paying the deceased person's debts.
Right. So what about taxes? How do taxes?
Well, taxes, there are all kinds of taxes.
Death and taxes are certain in life. How do taxes go with? Do taxes go with death?
Yes, it does, but not. Louisiana no longer has an inheritance tax at all, and the federal government has increased the exemption for federal tax to a very, very high level. So the only those people who have assets over $5,250,000 have a federal estate tax to pay. So if we have a $10 million estate, the first $5,250,000 is going to be exempt from tax, and the amount over that is going to be subject to a large tax.
But with proper estate planning, you might be able to avoid some of those tax consequences if you have such a large estate.
Correct.
Okay.
Through lifetime giving, use of trusts, and so forth.
Excellent. Well, we're out of time for this segment, but please stay with us, because when we come back, we will answer some of your questions on successions. Welcome back to Power of Attorney. We're talking about successions, what happens after you're gone. And we've reached the part of the show where we answer your viewer questions right here on our show. So let me get right to it. Liz writes, can I represent myself in court for a succession? What if my siblings are lying about what my father's wishes were for his will in probate?
And I think Liz's question means, can I represent myself in court as perhaps as an heir in my father's succession? And the answer is yes, but sometimes it is desirable or advisable for Liz to have a lawyer represent her. It depends on what the issues are. Right. And what if her siblings are lying about what her father's wishes were for his will in probate? Doesn't matter what they have to say. That's why there's a will. And if the will is validly drawn, they can say anything at all about what their father's intentions were. But if the document is drafted correctly, then the father's wishes are written in the will, and that controls.
Right. What if, and I remember from my days 20-something years ago in court, occasionally you'd have a fight where someone said that somebody had undue influence and they forced this elderly parent to write a will or to put something in a will that person really didn't want to have in the will. When you contest or you challenge a will, what happens if you believe that you think the will was something that was done sort of under duress, or the elderly person was taken advantage of and convinced to write a will that's not exactly their real intentions? Well,
if that's what you believe, you have the right to make that claim and to present evidence to show that that is correct, and you have the right then to attempt to knock out the will if it was done under undue influence.
In fact, what often happens is someone writes a will and then the children say the testator, the person who wrote the will, was not mentally sound at the time of the will. You have the right to challenge that too.
You have a right to challenge capacity, and if they can prove that the person who signed the will didn't have proper mental capacity to understand the nature of the dispositions, that's a way of knocking out a will.
Right. You can't just give your personal opinion. Usually you need to have some evidence,
You have
a
to have
doctor
it.
to give medical opinion based on the condition of the patient being treated before he died or things of that nature, correct?
Yes, and the kind of medication that person was on, but a lot of times it involves testimony of people who have been around that person at that time.
And if it's notarized, the presumption is the notary doesn't notarize anything without verifying that she's talking to a person who is aware of where he is, what day it is, who's the president, things like that, correct?
Yes, and that's one of the reasons why it's important to get the will properly drawn and to have the right representative putting that together to make sure that the will stands up as a valid document.
Okay. Karen writes, can I choose one particular person to distribute my assets in probate? That's obviously when you're writing your will, correct?
Yes, and the answer is yes, and that person that you name is going to be called an executor or an executrix, so absolutely that's one of the advantages to writing a will, is that you have the right to pick who you want to distribute your assets.
Excellent. Now, Tom has a question. What if a father had a child he does not know about when writing the will? How would that affect the will? What rights would that child have to any part of the estate?
Well, if that child is under the age of 24 when the parent dies, then the child would be a forced heir. But the child has a burden when it's the father who died, because the child has the burden of showing that that really is my father. If the father didn't know he had a child, then probably the father's name isn't on a birth certificate. Maybe it is, maybe it isn't. But there's still a time limitation where the child or someone acting on behalf of the child, the mother of the child, brings an action, it's called a paternity action, to establish that this is indeed the father of this child. There's a 1-year time frame. So
1 year from the date of death?
1 year from the father's death, or 1 year after the child turns 19, whichever comes first.
Wow.
So if it's a
Whichever
minor,
comes first.
then usually it's the mother of the child who would assert the claim that this is a child of this deceased person, and here's my lawsuit, and here's my evidence, and that's when sometimes DNA becomes important evidence.
Right. Another question from Ed. If my grandmother died in the late 1990s and my grandfather died recently, can we open the succession for both of them simultaneously?
Yes, if the grandmother died first and her succession was never opened, absolutely you can open both successions at the same time, and you can do them as a joint succession.
Excellent. So Ruth writes, can you sell your possessions or liquidate assets of something in your will to use or sell while you are alive?
Absolutely. The will doesn't become effective until you die. You have complete control over your assets. You may want to address what happens if you wanted to leave a possession to a certain individual. You might want to think through and have the will address what happens if I've sold it, because maybe you want the proceeds of the sale to go to that individual, but you don't lose the right to control those assets, liquidate them, do anything you want with them if you've written it into the will. And
I assume that it's the same answer even if you have children who would be forced heirs. You can sell off parts of your estate while you're alive. You could be a terrible manager of your property, in effect. The law doesn't prevent you from running your estate while you're alive the way you wish?
Absolutely. That's correct.
So a forced heir gets a forced portion, a piece of the succession, if they qualify as a forced heir, simply depending on what's left over in the succession, correct?
Yes, and there's sort of a yes but in that answer too, because sometimes the forced heir has the right to go back and see if the parent had given away assets to avoid the claim of the forced heir, while the parent might be on a deathbed, giving away assets to reduce the size of his estate to avoid the claim of the forced heir, or to limit the claim of the forced heir. So the forced heir is going to have certain rights to actually go back and see what happened prior to death, and possibly fictitiously add those assets back into the estate to make a claim.
Okay, here's another question, and it follows kind of a similar topic. What happens if I want to disinherit children, assuming that they would otherwise be a forced heir? Is there still laws that allow you to disinherit?
Absolutely, absolutely. If you have, well, for one thing, if you die without a will, all of your children are going to inherit automatically. So you have to have a will to be able to disinherit a child. But if the child is under the age of 24 when you die, you can only disinherit them if you have grounds to disinherit them. And typically, the only real relevant ground that people are able to use is if the child was estranged from the parent and refused to communicate with the parent for at least 2 years after becoming an adult. And then the parent would have to write a will that said, my son, John, after turning 18 years old when he was an adult, refused to communicate with me for at least 2 years, and therefore, and he didn't have any just cause for not communicating with me, he knew where I was, so I'm going to write this will and disinherit him. Even though he's a forced heir, he didn't communicate with me for 2 years, I write him out of the will. Wow. That's possible.
And when you say communicate, what if they send hate mail? That doesn't count, right?
That would not count.
Okay. All right, well, we have another question here. Cindy says, can I make a condition in my will that says to an heir, when you die, you must leave a certain amount of money to A, B, and C persons?
That you can't do. But once again, if your goal is to let someone use assets so that when that person dies, then the assets go to A, B, and C. We can do that with the use of a trust. So maybe in this question, instead, the answer is no, but we can set aside certain assets and give your heir the use of it, the income from it, a usufruct over it, and then when you die, when your rights terminate, your use and your usufruct terminates, then A, B, and C would get the assets.
Wow. Well, here's an excellent question. Suppose I die and I owe a lot of money. Do my children inherit my debt?
No. If the estate is insolvent, and I actually just had a recent situation with this where the father died and he owed more money than he had in the bank, and the children had to make a decision on whether or not they were going to take care of these bills, or should they just walk away, and the decision was made that they're going to walk away, and the creditors can come and make whatever claims they can, but there was nothing to be gained for the children of the deceased person to open the succession, to take possession of anything. But under any circumstance, they would not be responsible for anything more than what they inherited. So if they got the $3,000 bank account, and then the creditors saw that they had found out that they had the $3,000 bank account, the creditor can get them to kick back the $3,000 bank account.
Right, and whatever they might inherit, that's subject to the expenses of the succession.
Correct.
Lawyer fee, so that's deducted first, the burial costs and legal costs, correct?
Yes, but fortunately their own personal assets that they owned outside of the deceased person are not at risk, and that was actually a change in Louisiana law about 15, 20 years ago. It used to be that if you took possession of any asset of the estate, everything you had was subject to the claims of the deceased person's creditors.
So if there was something that had great sentimental value to it, but not
monetary.
Monetary value, you couldn't take that without taking on all the debts.
Exactly,
Wow.
but that's not Louisiana law anymore, so you're not at risk for anything more than what you received.
Right. Well, one thing that occurs to me is we mentioned in the last episode about community property. If one spouse dies and that spouse has a lot of debt, and it's debt incurred while the two were alive and while they were married, how does it work if the surviving spouse, if she maybe is living in a house, she's co-owner of property, does all the community property go towards paying debts?
And it could very well, the answer is it could very well, because if we're talking about community assets, we're probably also talking about community debt. So the surviving spouse owes, let's kill off the husband first, the surviving spouse being the wife, the surviving spouse is obligated to at least one half of the debt. So that can be very difficult for a surviving spouse.
Then let's jump back to estate planning. Some people actually get life insurance policies where the beneficiary is the estate to avoid an estate being in debt and having a surviving spouse also be made poor, if not homeless.
That is an option, but it's not always the best choice.
Okay.
Because in that case, now the creditors can get some of those life insurance proceeds. If instead the insured named the surviving spouse as the beneficiary, she can walk away with those proceeds, and at least his half of the debt she doesn't have to satisfy out of the insurance. She's still responsible for her half of the debt, but his half of the debt, the life insurance does not have to satisfy. So sometimes the planning would be better not to pay the estate.
Well, and I guess the moral of the story then is, God forbid you're taken from this earth anytime soon, if that stitch in time that saves nine, if you do your estate planning, if you figure out what you want to do to protect your loved ones from from unpleasant circumstances. There are things such as life insurance policies, there's trust, there's other things that you may be able to do to limit tax consequences and to maximize what might be left out of your estate for your loved ones.
Absolutely.
Okay, and an estate planning lawyer such as yourself, succession lawyers such as yourself, and those who do what you do are the best people to talk to.
It's our job to hear the client, to interpret what they want, and see what we can do to carry out their goals as best we can.
Thank you so much. That's, again, another excellent show on this topic. We are out of time, so please remember to visit the show online at John Redmann POA, where you can watch the previous episode with Ms. Neff. You can watch any other episodes. You can get all kinds of useful information about your rights. So you can find us on Facebook, follow us on Twitter. We love to hear from you, so keep sending in your questions. Thanks so much, and we'll see you next time on John Redmann, Power of Attorney. Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann. Shauna Sanford is out today. We very much appreciate your participation here on Power of Attorney. Your feedback and input is what we use to determine what we'll talk about each week. And since so many of you had questions about wills and estates and successions, we're dedicating a two-part series to estate planning and successions. What you need to know about how to plan for your passing and what happens to your estate, whether you've planned or not. We're fortunate to have an authority on estate planning with us today who has literally written a book or books on estate planning and successions. Stay with us, because when we return, Attorney Carole Neff joins the show to discuss some of the need-to-knows about wills, living wills, and related estate planning matters. Hello, everyone, and welcome back to the show. Today we're talking about wills, living wills, and other estate planning matters. We're excited to welcome attorney and author Carole Neff to the program to help us in understanding what you need to know about this important area of the law. Carole is a partner at the New Orleans law firm of Sessions, Fishman, Nathan, and Israel, LLC, where she heads the Estate Planning and Estate Administration Department. Carole is board certified by Louisiana State Bar Association, and she's co-author of this 3-volume treatise on Louisiana estate planning, which we'll show you in a bit. Oh, there it is right there. So it's important to know that she has also served as president of the New Orleans Estate Planning Council and is active and serves on the boards and committees of many other civic and professional organizations. Carole has received numerous awards, including Woman of the Year by New Orleans City Business and the Partners in Justice Award by the New Orleans Jewish Service Corps. Thanks again for joining us, Carole. We've got a lot of information to cover here, so what do you say we just jump right in?
That sounds great.
Okay. All right, well, estate planning, I think to most people that sounds like something rich people do when they've got a big estate, a big mansion out there like Downton Abbey. Tell us, what is estate planning?
Well, estate planning is really something that is something everybody really should consider doing, and it is not just for the rich, and it's not just about taxes. As a matter of fact, most of what estate planning involves is making arrangements so that when you die, your assets go to the right people, the people you want it to go to, and in the right way. So the planning side of it is getting your will together, and another thing that happens in planning is to plan for the possibility of our aging and becoming incapacitated, and powers of attorney are what we do in that area of planning.
Right. So estate planning is in more basic terms, it's just getting yourself together so people know what to do with your property when you pass away. And also, if you want to take that ounce of prevention, prepare in the event you have an illness or maybe even an accident that incapacitates you, so people will know what you want done with your estate while you're still living but incapacitated.
Correct. And also, as the population ages, we reach levels of incapacity when we age where we need others to assist in the management of our affairs. So part of estate planning is getting those documents put together so we have the right people in place.
And it makes good sense that while you hopefully are in a good place and you can think about what you'd like to have done with your estate, do it now rather than if you're incapacitated or disoriented with an illness. You want to take care of that now, so down the road people will know what you would like done with your estate.
Correct. And the right people are put in place as well, because if you don't make that kind of planning, then it could end up that a court picks someone and it might be the last person you would have wanted to be in that position.
In other words, you can name somebody to manage your estate, either when you're incapacitated and for after you've passed away.
Exactly. Yes,
All right.
indeed.
Well, we've got a lot to get to, so let's dig in a little deeper. So, do people need lawyers to do estate planning?
Well, I'm a lawyer, and obviously, you know, I'm going to say yes to that question. But aside from my own personal prejudices about the importance of using a lawyer, I'd even go a step further and say that it needs to be a lawyer that has some level of expertise.
Sure.
In planning estates, yes.
And certainly, if you've got a complicated estate or you've got a lot of things that you need to have done and you want to be certain they're done properly, an experienced lawyer who practices in your area of the law is the obvious choice. And let me say, because that's not something that I do. My area is really personal injury and some related matters. My advice to the viewers is you want to get a lawyer to help you with this. What if you really don't make much money? How much, suppose you you basically have a home, you have contents in your home, you're not well off. Is it going to set you back a lot of money to get the help of an experienced, qualified lawyer?
It may or it may not. Most attorneys that specialize in this area of practice bill on an hourly basis. So the more complicated, obviously, the more time a lawyer would have to put into it, but also most of us use paraprofessionals, paralegals, who are billed at lower hourly rates. Some lawyers bill on a flat fee basis, but the majority of people that specialize in the estate planning field bill on an hourly basis. But sometimes people think they don't have a lot of assets. They have their home, they have a bank account, they have their household contents, but they might forget that there's a 401k with work or an IRA, or they may forget that there might be a life insurance policy.
Very interesting.
And sometimes they don't take into consideration that they have more assets than they thought they did.
And to get to your point, a lot of times what you've done, that wheel's been invented. There's sort of the main things that people ought to do with their estate. It's fairly standard. Someone in your position who does what you do is able to make sure it's all done right, but you can rely on paralegals and other people to prepare the basic paperwork, get the basic information, and then you make sure it's done properly and you fine-tune it or finish it up. Is that a fair
correct,
statement?
and our goal there is to keep the cost down for the client. We know that that's sort of, it can be a deterrent to get people to do their planning, so we really try to make it as reasonably and cost-effective as possible.
Let's talk further then. So a big part of estate planning is having a will. In Louisiana, do you even need to have a will?
The vast majority of people need to have a will, whether they live in Louisiana or any other place. But when you die without a will, the state of Louisiana effectively writes your will for you.
In other words, you're not required to have a will by law, but it's just common sense, and it's a no-brainer that people should have a will, correct?
I would agree with that.
Okay. And even if you don't have a big estate. Well, you hear a lot of talk these days about living wills and use of living wills. How's that different from a will like a last will and testament?
It's very confusing for people because the terminology is so close. A will is the document that sets forth how your estate is going to be distributed when you pass away. A living will is actually the document that some people think of as the pull the plug document. That's the document that you sign when you're competent that says that if you are in a permanent vegetative state and two doctors say that you're never going to come out of this coma, that you don't want to be on life support. That's a living will, and it's limited to just that situation.
Okay. Now, just let's talk about wills. And they say last will and testament and a will for after you die. Same document, right?
It's the same thing.
Okay. What are some of the main things that you really need to have in a will for it to be a valid and enforceable document after you pass away?
Well, first of all, there are only two forms of wills in Louisiana that are valid. One is one that somebody could write themselves, but it needs to be entirely handwritten dated and signed by the person writing the will to be a valid form of will.
Right.
So a person in Louisiana, as in most other states, I think probably all other states, can write their own will, but they can't type it off of the computer. It has to be entirely handwritten, dated, and signed by them. That's a valid form of will.
And just to add to that, and do they still call it an holographic will? That's
They
the
do
term,
indeed.
fancy
That is.
law term I learned.
Yes.
If you have somebody help you write it all out for you, and they even write it in their handwriting, but then you put your signature and you date it and you do everything else, that's not good enough.
It's not good enough, and it will not be honored as a will. It'll be as if you wrote nothing.
Okay. And then the other type of will?
The other type of will is one that a lawyer prepares. In Louisiana, it's called a notarial will, and it's a document that is typewritten, and it's signed by the person who is writing the will. It's a person we call a testator if it's a man, a testatrix if it's a woman. It's signed by the testator on each and every page, and then at the end, and it's signed before a notary public and 2 witnesses. Everybody has to be present when the document is being executed. And there's a special paragraph at the end, this very important clause at the end that states that says that the testator said, this is my will, that the witnesses were present, that everybody watched everybody else signing, that the notary was there. And without that special clause, the document may be invalid.
So that's very important. And a big reason for that is you don't want people to pass off phony wills.
Exactly, and then you don't want them substituting pages, which is why there's a requirement that it be signed on every page.
All right, well, we got a lot to cover here. What about trusts? Define what is a trust, and how do trusts fit into this?
Well, trusts, there are all kinds of trusts, but the trust that is most commonly used with wills is a trust that's written into the will that is a management tool. So I want to leave something to my child, but my child is too young to manage it herself. So I create a trust inside the will, and I name somebody else, who we call a trustee, who's going to manage the assets inherited by my child. So it's a management tool, and it can be written into the will itself.
It prevents the child from taking the inheritance and going and blowing it at the casino, or basically getting rid of it all too quick and then there'll be nothing left.
And so, exactly, and so other people can't take advantage of them. They can't pull the assets out of the trust because the child doesn't have the power.
And then there's this can't lose investment they got to make, and of course they lose and lose investment.
Yeah, so we use trusts a lot in the wills that we do, and the vast majority of our wills have trusts in them for a variety of purposes.
And they even have some tax ramifications, or is that something that trusts don't have that much to do with?
Will trusts do have tax ramifications, and there is tax planning that goes into that too.
All right, we're real short on time here. What is forced heirship, and how does that relate to when you have children and what you want to do with your will?
Well, Louisiana is the only state that has forced heirship. We got our law from French and Spanish sources, and Louisiana does have forced heirship, although it's changed over the years. And the forced heirship concept is that a parent must leave a certain portion of his estate to a forced heir, and who the forced heirs will be descendants of that individual who are under the age of 24 when the parent dies. So it'd be a child 23 and under, or a child of any age who has a permanent incapacity to the degree that that child can't take care of themselves.
Can't support themselves.
Yes, so that's a forced heir. So when someone writes a will, they have to include the forced heir, and that's another way that we use trusts a lot.
Excellent, excellent. Well, we've got so much more ground to cover. However, we've run out of time for this segment, but stay with us, because when we come back, we'll answer some interesting viewer questions right on the same topic. Welcome back. We're wrapping up the first episode of a 2-part series on estate planning and successions with our attorney guest, Carole Neff. We've reached the part of the show where we answer your questions on air. So let's get right to it. Someone named Brady wrote in and says, what happens if I lose my will? So someone dies and they can't find the will.
That can be a problem. And we need the original will to present to the court, but the law does allow us in certain circumstances to use a copy instead of the original, but you have to be able to prove that the reason we don't have the original is not that the testator himself tore it up or burned it up or tossed it out, but that it was lost in the flood, or we just can't find it, or the attorney that was storing it died and we can't reach the family of that attorney, so here's a copy. So the court will allow a copy in lieu of the original, but it's very important to have the original available.
Right. So the moral of the story is, with your will and any of your important documents, you want to make certain that you keep it in a very secure place. It might not have to be a safety deposit box, but some place where you and your trusted family, any trusted family member or members, knows where to find it.
And has access to it.
And has access. Is it a good idea to make copies of the original just in case something happens to the original?
It is a good idea to make copies of the original.
And store that somewhere else, because if there's a home fire and everything in your house is gone,
exactly,
there's a backup
or
copy
there's
somewhere
another
else.
Katrina, and people have their original wills in their safety deposit boxes.
All right, let's see here. Teresa says, can you voice record your last will and testament? That's an interesting question.
No, that is not a valid form of will in the state of Louisiana. It has
so
to.
Even if you, I cut you off, I'm sorry.
That's okay.
So you always want to honor the last will, the will of the person who passed away, even if they videotape themselves saying, this is what I want to have happen to my estate. Unless they do a proper will, either the holographic type that's all in your own hand and dated, or the type that's done in front of a notary public. Without that, then the law decides exactly how everything is supposed to be divided
The
up.
Louisiana Civil Code will do it and will completely disregard this voice recording.
Well, there's a lot of people out there without wills, and despite best intentions, they might never get around to making a will. What does the law do with the estate of someone who has passed away and no will can be found?
Well, the vast majority of our estates, unfortunately, are those that people die without wills. And the Louisiana law does spell out who's supposed to get it and who's supposed to control it. But and it's going to depend upon who the relatives are, who are the closest relatives. Does this deceased person have a surviving spouse? Does the deceased person have children? When someone dies without a will and has children, the children inherit everything equally.
Whether they're married or not?
Whether they're married or not.
Okay.
If the deceased person has a spouse, the surviving spouse gets an automatic right to use the assets of the deceased person as long as those assets are what we call community property, created during the marriage, were not inherited by the deceased person. So the surviving spouse has certain protections, but they're very, very limited.
And that rule applies whether or not the person who's passed away, the decedent, has children?
The rule that would allow a surviving spouse to have the automatic use of the deceased spouse's assets is whether or not that person has children. If the decedent doesn't have children at all and has all community property, then the surviving spouse actually is going to inherit the deceased person's assets.
So an example is husband and wife are married 50 years. One spouse passes away. If they're a Louisiana couple and community property applies, then, and community property would apply unless you made special legal steps to avoid that, then the surviving spouse, the widow or widower, lives in the home that was the home of both of them, and gets to enjoy that home and maybe the family automobile and even the furniture and whatnot. Correct?
If it's community property, yes. The limitation, though, is that surviving spouse who has something, and what the word we're looking for here is usufruct. It's a Louisiana term. Use and
another
frus.
Fancy law term.
Yes, it is. A Louisiana
use and
fancy.
enjoyment of the estate.
Exactly, but that surviving spouse doesn't have the power to sell the house as a usufructuary.
Right, so you don't get to sell contents of the house. You don't get to borrow money on the house. Or maybe
not without the consent of those who actually inherited.
That are due to inherit.
And those would be the children, if they're children, or even grandchildren if a child died before the parent and was survived by children of his own. So this automatic right that a surviving spouse has is good to have, but very limited in scope. Limited in powers, and also if the surviving spouse remarries, those rights terminate at that time.
And that's by operational law. In other words, that's not something you've written in your will. That's just what the law says if there is no will.
That is correct.
Okay. And if you have grandchildren who, and maybe you outlive your children, but you have grandchildren who are under the age of 24, they're forced heirs as well?
Well, we get a little confused when we talk about forced heirship versus dying without a will. When somebody dies without a will, it's irrelevant who the forced heirs are, because children are going to inherit automatically no matter what their ages are. But when people write wills, then they have to be mindful of whether or not they have forced heirs. Grandchildren are not always forced heirs.
The parents have to be.
Certain grandchildren are going to be forced heirs. So a grandchild whose parent died before him and has a permanent disability is going to be the grandparent's forced heir.
Okay.
Or if there's a very young child, let's say 20 years old, who dies and has a child, if the child would have been a forced heir and dies before the parent, then the child's child, the grandchild, will be a forced heir of the grandparent. I mean, so there are limited circumstances in which a grandchild would be a forced heir.
Well, and let's get back to written wills, because we're short on time. There's so much to cover. What happens if you have a will but you don't update or amend it when another child is born, or if someone named in your will has passed away before you die and the will's not changed?
Well, those are really two different questions. So if the will was written before another child was born, and there's no provision in the will that says I leave it to my children who survive me, instead it says I leave it to my daughter and my son Jane and Joe, and then
here comes Susie.
Here comes Susie. Okay, Susie comes along, and Susie's not named. If she's not named, or there's not a general reference to a possibility of another child, then if Susie's a forced heir under the age of 24, Susie can come in and claim what we call the forced portion, but that's not going to be equal in that scenario to what the other siblings have received.
So if parents left everything to son and daughter, and then daughter number 2 is born before that person passes away, then maybe the 2 children get everything minus the forced portion.
Correct, and so the 2 children will get more than what the forced heir receives.
It does not invalidate the will?
It will not invalidate the will, but it will reduce what other people are going to receive to protect the rights of that forced heir.
Okay, all right. Let's see. Susan writes, can you write your will to exclude your spouse?
Yes, you can. Yes, you can. So if you don't want your spouse to have a usufruct over your assets, you can leave assets outright to your children or your favorite charity or your best friend. You don't have to provide for your spouse.
Someone else wrote with a question, can someone else change your will?
No, that is not allowed. Only you have the power to change your will.
Right. Patrick writes, can I write my will with conditions like Susan is to receive the house only if she graduates from college?
Well, there's sort of a yes and a no to that answer, or it depends. We have to know who is entitled to inherit at the moment of the death of the deceased person. So if we're delaying for years to find out if Susan's going to graduate from college or not, that would not be a valid condition. On the other hand, if there was a trust that says we're going to put the house in the trust and the trust is going to be turned over to Susan when she graduates, that would really be okay, so that if she never graduates, then the trust will still own the house. So there are ways to respond to that and get what the person wants.
If you're not a lawyer who specializes in this area and you try and write your will to do all this, there's a good chance it's not going to be accomplished if it's a special condition you want like that. But
it takes some knowledge
and training of a lawyer who does estate planning, you can take steps to make a lot of those conditions happen, or at least
we want to hear what our client's goals are, and then our job is to write it so that those goals are able to be carried out as best as possible.
All right, well, to sum up a little bit, if you have no will, the law says that it dictates where your estate goes, correct?
Yep.
And typically speaking, let's say your average married person who's still married when he dies and they have young children without a will, the children would inherit everything.
Correct.
And the surviving wife or surviving spouse would be allowed the use and enjoyment of whatever's in the estate.
That's correct. Now the limitation, though, is that with these minor children, let's say the surviving spouse finds that it's time to sell the house, and since husband died without a will, she doesn't have that power. She'd have to go to court and start what's called a tutorship proceeding for her minor children. She'd have to get the court to appoint her as tutrix. She'd have to get the court to approve the sale of the house. So it adds a lot of complexity.
And all that complexity is really there to make sure that the young children don't get taken advantage of and have their assets sold out from under their feet, and then there's cash left over, and then the cash is burned up before the children reach 18.
Right, so that's why the law is written that way, to protect the rights of the children. But when somebody thinks about that in advance and writes a will, he can put a trust in the will for the benefit of the children. He can name his spouse as trustee to give her powers that she would not otherwise have. He can name somebody else if he doesn't want his spouse to be the trustee. He can name someone to follow the spouse if the spouse can't do it forever.
We're almost out of time, but what happens if somebody moves to Louisiana and they came from a state that doesn't have forced heirship and they have a written will, and they establish residence here? They're not just passing through. Do the same laws on successions and estates apply to that new resident of Louisiana?
It would. It depends on the domicile of the deceased person. Where were you living when you died? And it's the law of that domicile that dictates how your estate is to be distributed and what law applies.
Wow, well, you've given us so much helpful information. We're very grateful to you for being here. The only problem is we've run out of time. So, but we're going to have you back on the very next episode talking about successions and actually talking about what happens to the estate after someone has passed away. So stay with us. Remember to visit the show online at johnredmannpoa.com, where you can watch this and other episodes, and you can find more information about what we've talked about today. Of course, you can find us on Facebook, follow us on Twitter. We'd love to hear from you, so keep sending in those questions. Thank you so much, and we will see you next time on John Redmann, Power of Attorney. Welcome to this special web-only segment of John Redmann, Power of Attorney. We've had two excellent shows with Carole Neff talking about estate planning and also successions. In this segment, we're going to get a little bit more out there into the specifics on estate planning, things that you want to know and be thinking about in order to do your estate planning, or maybe to tweak the estate planning you've already done. So, Carole, thank you again for being with us. You spent decades in the business of estate planning. You're highly regarded and in the specialized, and it's a specialized field of estate planning under the Louisiana Bar Association rules, correct?
It is, very specialized.
Area. I have enough sense to know that I don't know nearly enough about it to do it for myself. I would go see someone like you. But for those people out there who wonder, what's all this estate planning business about? Can I afford it? Why don't we go over the things that are involved in doing estate planning, just the basics. For example, what should you be thinking about when you're going to go see a lawyer for setting up your estate?
Well, let's use an example of a married couple with children. And the things you want to think about are what happens if the husband dies first, and what rights do we want the surviving spouse to have? If husband and wife both die simultaneously, we should be thinking about who should manage the assets for the children until they're old enough to manage it themselves, who should raise the children if both spouses are gone. So those are the kinds of basic important things to think about in advance. Who would my first choice be? Okay. Who would my second choice be?
Okay. And just from a practical standpoint, before you go to see a lawyer, you want to know, how much is this going to cost me? So either you know in advance, or you can call the law firm and get an idea of what the consultation is going to cost, correct?
Yes, you're absolutely
correct. And at your firm, do you mind telling us
we
what the
bill everything on an
is?
hourly basis. So it's my time, the amount of time I spend. So if somebody comes in to see me to consult with me on planning an estate, they're going to be paying $350 for my hour. But I have younger partners and associates who are billed at lower hourly rates. So sometimes, if that's daunting and that's too much for someone,
don't let that be excuse. Hopefully, you can find
there's someone else who might be billed at $210 an hour or $250 an hour. But once the consultation takes place and we have a really good idea of what documents need to be done, then we turn things over to the paralegals to draft so that they're billed at a much lower hourly rate.
Great.
When people call and ask how much is this going to cost,
Right, that's my
I
next
can't
question.
give them an exact figure because we don't bill on a flat basis. Depends upon the amount of time that's going to go into any project, and that's going to be dictated much more by the client than by me. But I can at least tell them that most people fall in a range from $1,500 to $3,500 for husband and wife wills that are going to have trusts in them, that have some tax planning that goes into it, that will give them financial powers of attorney, medical powers of attorney, and living wills. Really, the whole necessary basic packet of estate planning documents within that range.
Excellent, excellent. So suppose someone has decided they're going to go forward with an initial consultation with you or somebody else. What sort of, what should they be thinking about before they actually sit down and talk to the lawyer?
Well, for one thing, it would be very helpful to the lawyer if they had in advance listed their assets, identified the nature of their, this is what we have in the home, this is what we have in other real estate, bank accounts. And we don't need to know account numbers or what financial institutions, but so that the lawyer has a general idea of what kind of assets this married couple has, what the spouses might have inherited from family members that might be their separate property, the nature of the debts, whether or not they have life insurance, whether or not they have IRAs and 401ks. That kind of information is critical for being able to steer the client in the right direction, to address all the different choices that there are to make. Like, for example, we decide that it's important to have a will that has a trust for the children, and we find out that the client has life insurance. Well, we want to make sure that the beneficiary designation for the life insurance coordinates with what we've done in the will. So we're going to help the client make a beneficiary designation so that anything that was going to go to the children goes to the trust, the trustee of the trust that's created in the will. So we need that kind of information. So you come in with a list or an overview of what the assets look like.
Should you also bring bank records, deeds, stocks and bonds?
You really don't need to go into that level of detail. As long as it's just identified by category, I have this amount of value in stocks. I have this amount of value in bank accounts. That's good enough for us to.
I have a house and I owe a lot of money on it, but there's still some equity in the house. You'll want to know.
That's good enough information. It's general, but it's good enough for us to be able to get a proper will drafted.
Okay. And so what should the objective be? What can you hope to accomplish in the first consultation?
I find that most of the decision making is actually completed in that 1.5 hour consultation. Sometimes there are decisions yet to be made that we can communicate about after that initial consultation. But most people are going to come in with an initial consultation that'll run 1 to 2 hours. We'll go through what the family looks like, what the assets look like, what the goals of the parties are. We'll talk about a lot of different scenarios. What if this person survives? What if this person doesn't survive? So that we can address all those possibilities. And by the end of the first meeting, normally I have enough information to get a paralegal involved in drafting wills, powers of attorney. There might be some decisions to make, and then we'll be communicating by email,
maybe the spouses
phone.
need to talk further on their own about, do they want to set up the trust to do this? Do they want to set up this other plan to do that?
Yes, or how old should our children be if we're both gone before we think they're ready to have the assets turned over to them? Should we give it to them in portions? Should we give them a third when they're 25 and a third when they're 30 and another when they're 35? Do we have a child that's permanently disabled, so we need a trust for the life of the child? Do we have a child that has who's a spendthrift and we don't want to hand assets over to this individual, so do we want that trust to be longer than for the other children? So we pull that kind of information out in the course of that consultation.
Right, and obviously when you're talking with parents and they have young kids, you hope your child is going to grow up and be very well behaved in handling their finances, but a trust may be a protection just in case the child turns out to be not so good with handling, saving their money or keeping their money in check. And these are things you can talk about in that consultation.
Absolutely, and actually what some of that addresses is sometimes people have done their wills years ago when their kids were babies, and now the kids are getting older. So what that really deals with is updating your estate planning. So what was important and the decisions we made then that made sense then don't make sense anymore today. So we need to update them. We need to make amendments to our wills, or maybe we need to do entirely new wills.
Right. And often, maybe not in every occasion, after that initial consultation, you can have sort of a game plan of this is what I recommend, and assuming you want to do this, that, and the other, prepare this type of will and have this sort of whatever you need to prepare. There's going to be some general idea of the main objectives and
a direction, yes.
And maybe a price range. You say, well, to do all this, you're probably looking at, even with paralegal support, maybe it's going to be $1,500 at the end of the day.
I'm in a better position after I've had that meeting to be able to more fine-tune my idea on what the cost would be.
Right, well, we just have a minute or two left. Can you give us a couple of good examples? What are a couple of the best things you recommend in most wills or estate planning situations?
I'm going to recommend in most estates that there be some form of trust. And it might just be to protect the surviving spouse and give the surviving spouse more power. I'm going to suggest that there are alternative appointments. They have somebody they want to name as an executor, but what happens if that person isn't around or can't do it? So alternative ideas, a lot of thinking through the different scenarios that could occur. So I think those, talking about whether or not charitable giving is one of the goals of that family, and whether or not there ought to be special provisions for that, or maybe there are special belongings that an individual wants to make sure goes to one individual.
You want to make sure Billy gets the the classic car, and Susie gets the
jewelry
amazing collection of jewelry.
Yeah, exactly.
Okay. Well, you've given us plenty of helpful information. We're grateful to you for joining us here on the show, and we look forward to having you back to talk about more of these excellent and useful topics.
I would be delighted.
Thanks very much. That's all the time we have, ladies and gentlemen. We look forward to seeing you on our regular show, John Redmann, Power of Attorney. Visit our website, johnredmannpoa.com. You can see other segments. You can catch any of the TV shows. There's oftentimes useful information that you can download and checklists and things of that nature. So thank you for being with us, and we look forward to seeing you another time very soon.